Hey, Paul here again, and in this video we're going to talk about the conversation that married couples need to be having with each other about what happens when one of them dies, and they need to have this conversation before they go see the estate planning lawyer. Okay, so in my most recent video called 10 items married couples should discuss before they meet with an estate attorney, this issue that I'm going to discuss in this video is numero uno. In fact, I'm going to link you to that video where I just briefly described all 10 issues that married couples need to be talking about, and I'll link that to you right there. Okay, but this is numero uno, and it's how married couples will leave things to each other. And you know what? You really need to be discussing things before you're just sitting there at a desk with a lawyer and he just throws this stuff at you. The lawyer may try to kind of influence you into going a certain way. Maybe that's because that's easier for the lawyer, or maybe that's what the lawyer thinks you should do based on the lawyer's prior experiences. But I really want those married couples to have a conversation privately by themselves. They can talk it out, but it needs to be an informed conversation. So the purpose of this video is to get it informed. So let me give you some examples of the types of ways that married couples can leave things to each other. And to do it, I got to give an example. And so let's say a married person has an estate and it's worth $1 million. And really, this conversation would be the same whether they had an estate worth $100,000 or $10 million. I'm going to use that round $1 million figure. And of course, it consists of, probably a home and savings and other investments and other assets. $1 million. Okay, so option number one is married couples or a married person with the $1 million estate leaving, let's call it ownership of their estate to their spouse. Real simple to understand. Let's say the husband dies first. Husband has $1 million estate. He leaves ownership of it to his wife. After he dies, wife owns it all. In fact, when most couples, hear that as option number one, many of them are like, that's what we want. We don't even need to talk any further. Sounds simple. That's what we want to do. Easy to understand. But upon diving a little deeper, we have to talk about those things that may get a little bit uncomfortable, so those married couples can make informed decisions. One of the issues that causes married couples to say, maybe that's not what we want, is because when that husband leaves that $1 million estate to his wife, she can do whatever she wants to with it. Of course, she can spend it. It's hers to own. But the potential problem, and many people have seen this, is that surviving spouse then could leave that estate to a new spouse that they get. Or the surviving spouse could leave that estate to just one of the children. And so there's no protection for the heirs or children of the first spouse to die when that first spouse to die leaves ownership to the surviving spouse. We could say two things could happen once the first spouse dies and leaves ownership of that $1 million estate to the surviving spouse. In general, two things could happen. Either the surviving spouse intentionally leaves their estate to someone else, a new spouse, some third party, and they do it intentionally because maybe one of the heirs made that surviving spouse mad. Or the surviving spouse could unintentionally, maybe because the surviving spouse got very old, was in their 90s, maybe in their 80s, and they started losing capacity. And so someone influenced that surviving spouse into signing something so that the children or heirs of the first spouse to die wound up with nothing. And yes, if someone does adversely influence that surviving spouse, potentially those heirs of the first spouse to die or heirs of the second spouse to die, potential heirs, may have some recourse, but all that stuff is real difficult and requires a lot of litigation. So that's the downside of a married person just leaving ownership of their estate to their surviving spouse. So then once, the couple that I talk to hears that, then they're like, well, Paul, what's option two? You said there were two options. Option 2, and there's another couple of options that I'll go over with after option 2, but option 2 is really an arrangement where when the first spouse dies, that spouse's estate perhaps is available for the surviving spouse, for the surviving spouse's needs, and then when the surviving spouse dies, that first spouse to die's estate, reverts back to the heirs or children of the first spouse to die. And so that's often done through some type of trust arrangement where the husband, he wants to make things available for his surviving spouse, but he also wants some protection for his heirs or his children from the surviving spouse doing something kind of wacky. So the husband's estate planning documents are set up so that when the husband dies, his estate goes into a trust. Typical that his surviving spouse would be what's called the income beneficiary of that trust. So if that $1 million of assets produced some income after the husband died, that might be interest or dividends or rental income, then the surviving spouse would get that income that the $1 million of assets produced. And these trusts often say that if that surviving spouse needs principal from the husband's estate or from the husband's trust for her, the typical standards, health, education, maintenance, or support, then the trustee of that trust after the husband dies can make distributions to that surviving spouse for her health, education, maintenance, or support. And then when that surviving spouse dies, this trust terminates and the assets are dispersed out of the trust to the heirs or children of the husband or the first spouse to die. One of the key issues is if there's going to be that arrangement after that first spouse dies with the $1 million estate and it goes into a trust, who's going to be the trustee of that trust? Who's going to be the trustee who makes the decision regarding whether distributions should be made to that surviving spouse for her health, education, maintenance, and support? And it's common for married couples to say, I'm going to leave my estate to a trust and I'm going to name my surviving spouse as the trustee. I trust my spouse to do what's right. And so that's common, but then sometimes we say, well, married couples might say, well, the $1 million estate guy may say, when I die, I want my spouse and one of my children to be co-trustees so that there's a second pair of eyes, taking a look at those distributions that are made out of the trust to that surviving spouse under this HEMS standard, health, education, maintenance, and support. All right, so that's a key issue, but that option number 2, where husband, if that's the case, leaves his $1 million estate to a trust, in general, what he's doing is he's making his estate available for his surviving spouse's needs, but the surviving spouse is not going to be able to change where those assets go when the surviving spouse dies. Those assets must revert back to the heirs or children, however he designated it, of the first spouse to die. So some couples really like that concept, and then you see sometimes couples saying, well, heck, if you die first and you leave things to me, I ain't getting remarried, so it won't really matter how you do it. Might as well leave me ownership because I ain't getting remarried. And then you'll see some spouses say, I know if I die, you are going to get married probably before I'm even in the ground, so I want to do it this way, blah, blah, blah. So it's again best that y'all have those conversations privately instead of, in front of some stranger who you just met. All right, so now here in Louisiana, we have another option. It's called Usufruct. It's kind of like the trust arrangement. It's where husband dies with the $1 million estate. He says his wife leaves his wife Usufruct, which basically says she can use it, she can receive the fruits of it, but then when she dies, the naked owners or the heirs of the first spouse to die receive the assets. I'll put a link to a video that I made called What is a Usufruct right about there, so you can check that out. Some key points here: you can do a mixture. Some couples will say, we want to leave the house to each other in full ownership when one of us dies because we want the surviving spouse to be able to do whatever they want to do with our home, But when one of us dies, the rest of that spouse's estate will go in a trust, and with the protections for our children in place. So there can be a mixture, ownership of some assets in trust. Another key point to remember is that all of this stuff in your estate legal documents, it doesn't control the disposition of things like your IRA, whether that's your traditional or Roth IRA, your life insurance, your annuities, those assets where you can name a designated beneficiary. Your estate legal documents say, I leave things in trust for my spouse. Then when my spouse dies, I want them to come back to my kids. But if your IRA beneficiary designation lists your spouse as the 100% primary beneficiary, when you die, that IRA is going to be 100% owned by the surviving spouse. So just realize that those things where you have beneficiary designations that control the estate planning documents really have no effect towards those assets, unless, of course, on the beneficiary designation stuff, you list your estate or a trust as the beneficiary, but that gets a little bit complicated, and that's beyond the scope of this video. One other thing that's real important, it's kind of top secret, so I gotta be real careful about it, is gotta make sure nobody's around. You wanna make sure that you subscribe to this channel so you don't miss anything. If you already subscribed, hey, awesome, that's fantastic. That way you're gonna be fully informed, because I got 9 more videos coming up where you can find out all the things that you and your spouse need to be talking about before you go see an estate lawyer. So that's what the next 9 videos will be. Hey, thumbs up if you've got some benefit here, constructive comments down below. We'll see you on the next video.